The issue is you exploded because she got dirt in your tool. You didn't like that. You tried to take something away from her and she stood up to you. She took control. You did not like that. We will go on the record in the matters 23 CF 189, 24 CF 163, State of Wisconsin versus Christopher Stewart. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Stewart in person with counsel Nicholas Davis. We're set here today in this matter for two things. One is for a status conference on 24 CF 163, and the other is for a sentencing hearing in 23 CF 189. Mr. Davis, can you please give me a status on the 24 matter before we proceed?
Your Honor, it's not resolved, but may I ask you for a little more patience? I think it has the potential to resolve. I just need another opportunity to speak with District Attorney Schmidt. I'm not asking for that 90-day mumbo jumbo. If I can just have 30 days, Judge, I'd appreciate it.
All right, for that matter, all right. And we are in victims' rights compliance for that matter, yes. Okay. And are we in victims' rights compliance for the 23 case? Yes. Okay. Are we ready to proceed on the 23 matter?
Yes, Your Honor.
Okay. Well, with the 24 matter, Mr. Schmidt, Mr. Davis is asking for additional time to be able to negotiate with you to see if the matter can resolve or if we do need to set the matter for trial. I don't believe that we've had any type of speedy disposition request from either Mr. Stewart or from victims. I do know that victims would like to get the matter resolved as quickly as we can, but not, it hasn't been requested to get it done now, so to speak. So is an additional 30 days objected to?
No, and basically nobody wants to have trials where young children have to testify if they don't have to.
All right, so then that's fine with the 24 matter. So we can go ahead and get that set right now for an additional status and see where we're going to go with that. Mr. Davis, you are coming back on February 10th at 11:30. February 10th at 11:30. We can go ahead and set that at that time.
Yes, Your Honor. Thank you, Your Honor. Your Honor,
What's the
and
date on that?
What?
I missed the date on that.
February 10th at 11:30.
February 10th.
Your Honor, those other two matters, you allow me to appear by Zoom. May I appear by Zoom for this, please?
You may.
Thank you.
Okay. Now let's proceed to 23 CF 189 for sentencing. Mr. Schmidt, you may begin.
Sure. This is kind of a hard one to do for sentencing, in part because it's a deferred judgment conviction that got revoked for commission of a new crime. The defendant has not been convicted of the new crime. He's presumed innocent of it. Normally what I would say in these cases is I usually go for a probation first when there's revocation of a DJOC, and that's because most of our revocations for DJOCs are for non-payment of fine or them not doing like the programming required on the DJOC. Mr. Stewart's done the programming on this DJOC, so probation, do anger management, DV, that wouldn't make sense because he's already done that. I'm going to be asking for some jail time on this, and the reason why has to do with his history. If you look at CCAP, Mr. Stewart looks like he doesn't have much history. If you look at CCAP, you see a single forfeiture ticket in Grantsburg for DC. You see Minnesota, some weird misdemeanors for traffic violations regarding equipment violations in a 2008 DUI, and that's it. When I look at it in Protect, though, I see there have been a lot of charges filed against Mr. Stewart over the year, and I wondered why none of those show up on CCAP. And the reason why is 2019, Mr. Stewart, domestic DC, did a DJOC there, completed it. That's why it's not in CCAP, got dismissed. Did a DPA on another domestic DC in 2017, completed that, got dismissed. ordinance on a DC in 2014, another ordinance on a DC in 2014, ordinance on a domestic DC 2011, 2005, felony child abuse, DPA completed, dismissed. So there is a trend that goes back 20 years, at least, to disorderly behavior, domestic related behavior. That's gone unabated. It also shows that when he's completed numerous DPAs and DGOCs, meaning he's done the conditions without getting in trouble on those. This would be the first one I believe he hasn't. For that reason, I think the court for this, the DGOC wound up being on the misdemeanor battery. I think the court should consider jail time between 3 and 6 months. I think 9 months would be too much because I don't know how much jail he's done in his life. It can't be a lot. I can't imagine he's done more than 10 days jail at a time. So ratcheting up to 9 months wouldn't make sense given his lack of actual criminal history. But I think because I don't see what probation would do in this case. We're supposed to first consider probation. I don't know what need they would actually address because he's fulfilled the programming requirement of the DJOC. I think that we're really about punishment and we're really about like deterring the behavior. I'm hopeful that getting jail for the first time for this sort of conduct ever might deter his behavior better, because he's been charged with it and gotten ordinance or DPAs and DJOCs constantly for this sort of behavior. Thank you.
So I guess I missed, how much did you ask for?
I asked for between 3 and 6 months, Joe.
3 to 6 months. All right. Mr. Davis.
Thank you very much, Your Honor. So, Your Honor, while that may be true that he have had deferred cases in the past and successfully completed them, that resulted in no conviction. And so you have to look at the convictions, not stuff that was where he did not get convictions or receive convictions, whether it be an ordinance or deferred. Now, Judge, this is a lot different from those other cases, and I'm going to be quite poignant on this. We were prepared to go to trial on this, and the issue, first of all, I'll say that this is a serious offense. I think it's a lazy argument to say it's a misdemeanor or it's a low-level felony. Let's just get that out of the way. This is a conviction. This does not bode well on his record. My client is employed full-time, and he will not get business if people start doing searches on him and seeing misdemeanor convictions. That doesn't help him. Or if he wants to switch and go to a company or a different company, this obviously isn't going to be a badge of honor. But this specific situation, so he was building a house, and he has his daughter. It's a separated family. They're divorced. So there's the child, the ex, and he, and they have shared placement time. And she comes over, and every time she's at that teenage age where she'd have chores, she wouldn't do them. She wouldn't do her homework. She wouldn't help with the chores. She wanted a new house, and he did everything to build this new house on what I call a creek, not a river, but a beautiful home that he wanted to build for he and his daughter. And they were working. And he kept telling her, "Will you start helping? Will you start helping clean up the lumber?" And he did take a piece of lumber, Your Honor, and he did not intentionally throw it at her, but he threw it in her direction, and the board hit her. And he was a frustrated parent. He wasn't trying to hit her or smack her or take a board and hit anybody. He's like, "Come on, you just help, start working, start helping with the chores, help me around here. Not just don't come over and sit on your phone or your iPad or whatever it is." Now, yes, he could have tried something different, maybe grounded her or time out, but he threw a board, but he did not try to take that board and throw it at her and hit her with it. In any event, he understood that that's not how to handle that situation. He entered into the deferred judgment of conviction, and he did have some requirements to do an anger management assessment and follow through, which he did do, Your Honor. And then I believe he also had another assessment with, I think, parenting and child parenting, and I believe he completed that. What's really tough right now is that he hasn't had much contact with her and hasn't even had so much as seen her in months, didn't see her for the holidays. And now I believe she's moved from Grantsburg School, Your Honor, where she's always gone, and now she's moved to Pine City School. Her grades are abhorrent. Her grades were not doing well in Grantsburg, but I believe they're even worse now. And so I know that children, they like to make decisions. And I know that if you're under 18, you're a minor, you're a child. And it's a lot easier, Judge, I know you've seen this, to be with a parent that gives you the freedom, the video games, that can do whatever you want, and all these things. And yeah, that's nice. And sometimes the parents migrate towards that. And sometimes the parent that has homework time, we sit down for dinner together. You need to help me with some of these projects around the house, and you have chores. Yeah, that's not the fun parent. I know that. I had two parents like that, and there's always a chores, or there's always something. And when I'd see my friends playing or skateboarding or swimming, and I'd have to do these things, yeah, I thought I had the worst parents in the world. But looking back, I didn't. I had parents that cared enough to want to see me have some structure and succeed. What I'm getting at is he's got this criminal conviction for misdemeanor battery, and his daughter was involved in this. And again, he took a piece of lumber and he was upset with her, but I just want you to know, Judge, he did not throw that to hit her with it. He was, get going, get your butt moving here, help me out. So, Your Honor, he does work. He makes all his child support payments. He does whatever he can to support his daughter. Strike that. I don't know if there are, I'm going to strike that, the child support payments. I don't know enough
No,
about.
I know that. And I saw him say, no, he doesn't.
Well, he, and I don't know, I don't do family law anymore, and I'm certainly not representing him in this family law case. And I think there's something going right now currently with that, but so I'm not representing him on that. But I do know that when it comes to any extracurricular, or if there's clothing or whatever it needs, she's not denied any of that. And quite frankly, he's going through, I think, hell right now because he can't talk to her. I don't think the mother's allowing him to speak to her. And quite frankly, I don't think there's any order of this court that denies him that contact. I think if he is to be around her, it's got to be with someone supervised or someone 100% there with eye contact around him. I think that's my understanding with any 18-year-old or younger. But in any event, he's still being denied that access. And so I don't, again, I understand, is this a serious offense? Yes. What is the character of the defendant and his rehabilitative needs? I think his character is strong. I think he did everything he could to follow the deferred. Again, he's got another charge pending, but he does enjoy the presumption of innocence. And that case, again, is not resolved. And I don't want to go any further into that because there's really no reason. It's the presumption of innocence, but it's because of that case is the catalyst, and it did not involve his daughter. It's because of that case we're here for this. And it had not been for that, I know he would have successfully completed this agreement. So what's the need to protect the public? Well, now he's not around his daughter. And it's basically just him and working, but he's not an alcoholic. He's not a drug user. He's a hardworking man, pays his taxes and supports anything he can with regard to his daughter's success. And so, Your Honor, the only thing that I can think of is I know anger management. I understand what it is. I understand what the assessment is, but sometimes I think the domestic violence assessment, which is much different, and usually that entails fall through, and also entails that the therapist needs to see the criminal complaint and as much documents as they can see. And I think sometimes that assessment may be something that may be more forthcoming or can see if there is any issues there because it was his daughter, and they are in a domestic relationships and the definition of it. So I think that assessment, I think it's much more in depth. And I think the anger management assessment, while it's good and it can assist, I think that the domestic violence, I think it not only covers anger management, I think it covers a whole litany of things with regard to being a father and how you act. And yes, if you get frustrated also, I think you get frustrated, you don't throw lumber or, although I've had many times growing up where maybe my father wasn't right, but I certainly had things like that happen as well, where he was.
And that wasn't right, Mr. Davis.
Well,
that was abuse.
No, I love my father, and it made me a very successful person. He never hit me, but he would say, get going, pick it up. He never hit or hit me with any lumber or anything, but he was very hard on me. And I know my father never abused me, and he's a wonderful, wonderful father. But what I'm getting at is he was hard on me, and I think that created a lot of my success. And so I thank him for that. Now, again, this situation, had it been handled differently, maybe he pulled his daughter aside, but I think where his head's at, I really want the court to know this, his head was not to be mean to her, not to hurt her, but he wants her to be successful and have some structure. And again, I don't know anything about the mom. I don't know, but all I know is I don't think there's the same structure there as it is when it's at dad's house. And so he's the mean parent or the bad parent because of that. In any event, Your Honor, I'm asking the court to consider probation. And this is a heavy duty. My client and I discussed this, but I think it should be probation with an imposed and stayed for the whole time. And he completed domestic violence assessment and he follow through. And that way the ball's in his court. So if anything should happen for the term of probation, then he doesn't, not 3 months, not 4 months, but the whole entire deal. I'd ask the court to consider, because he is full-time employed, that he would be allowed Huber. But I think that's a heavy hit. Put it on him, put the anvil on him, and that's an imposed and stayed for the entire time. Thank you very much.
Thank you. Ms. Bauer, do we have any victim impact statements? I have nothing in the file, so I don't know if anyone's going to make a statement. No, Your Honor.
I received nothing in terms of that.
Is this the victim in the courtroom? No, this involves a different matter? Yeah. All right, okay. Okay. Mr. Stewart, I am now going to turn this over to you. This is going to be your opportunity for you to provide me with any statement that you wish to provide me with. And let me know anything that you wish to let me know as it relates to this matter and any other matter or any other thing that you want me to know and understand. You don't have to, but it's your only opportunity.
I don't know. I don't know.
You don't have to.
You don't have to, but if you want to tell the judge anything now, this is your right to do that.
No, I don't know what's going on.
All right. Mr. Davis, I fully understand where you're going with, where you were coming from with your argument. And I fully get, and when you were telling your story of how you grew up, Mr. Davis, I get it and I understand. I too had very strict parents. I too had a father that was very strict. I too had a father that was very much like Mr. Stewart, not like your father, Mr. Davis. Not like, if I am going to guess 100%, Mr. Davis, your father did not throw a board at you.
No.
I don't know if your father was angry and your father threw things when he was angry, but it's not okay. It is not okay in any way, shape, or form. No way, shape, or form. That is abuse. Even if you had zero intent to hit your daughter, that is abuse. It is abuse. It causes emotional trauma within your child to see you act like an idiot, like a jerk, like even more words that I cannot even say on the record. You were an awful parent that day. And if I read from the criminal complaint of what happened that day and how it went down, the officer responded to the address and made contact with Ben Stewart in the front seat of a pickup with juvenile 1 sitting on the passenger side of the truck. Ben told me he was taking juvenile 1 to get checked out at Burnett Medical Center. I had juvenile victim 1 get out of the truck and talk to her. Juvenile victim 1 was crying. She told me that her dad, Chris, had told her to use the tape measurer when they were working in the yard. Juvenile victim 1 had gotten dirt in the tape measure, and Chris had told her that if she did that, she would not be going deer hunting. Juvenile victim 1 then was upset and told Chris that she was going deer hunting with her uncle, Ben Stewart, and he would be taking her. Chris then threw a board at her, which hit her in her arm. Juvenile victim 1 showed me her forearm, and I could see a mark on her arm where the board had hit her, and a bruise was starting to form. Okay? And then it goes on and says that he threw the board during the argument, but didn't mean to hit juvenile 1. That's what you told the deputy. He thought she would, quote, get out of the way, quote. You thought she would, quote, get out of the way, quote. When you threw a board at her, you hoped you thought she would get out of the way. When you were mad that she got dirt in a tape measure, and now you said, nope, sorry, I'm taking away your pleasure of going deer hunting, which is great to teach a young lady, by the way. And you said, nope, I'm taking away your fun. You're no longer going deer hunting because you got dirt in my tape measure, because I love my tools, because that's what I do. And so I got mad. No, you're not going deer hunting. And then she said, no, Dad. In parentheses, I may not be going deer hunting with you, Dad. I'm going deer hunting with my uncle. And I'm going to presume uncle's your brother, Ben, because Ben at that time, I'm guessing, was siding with juvenile 1. Because how it laid down here is you thought she would get out of the way. You don't get angry over things like dirt in a tape measure. It's not like she was not picking up the lumber. It's not like she wasn't doing her homework. It's not like she wasn't cleaning up her room. She got dirt in the tape measure. And you got upset when she wasn't listening because you were trying to take something of pleasure away from her. And she said, no, Dad, too bad. So you threw a board at her. And your excuse was, I thought she'd get out of the way. But she didn't. Because you know what? A man throwing a board, a heavy, I'm going to guess 2x4, goes fast. If you've ever taken science class or a calculus class or anything like that, and you do all of those mathematical formulations, they go pretty fast. Okay? It's kind of hard for, I think, a 15-year-old, if I'm recalling correctly, to get out of the way. That's rage. That's not a good parent, Mr. Stewart. That's not a good parent at all. That causes trauma that she will have to live with, and she will have to try and figure out throughout her entire life how to resolve with or without having you in her life. Trying to build boundaries with having you as her father, because she doesn't get to choose. She didn't get to have that choice of, God, let me see, who do I want to have my father? Should I be born to, someone famous or Christopher Stewart? I'll choose Christopher Stewart. She didn't get that choice. And I'm not sure if you even truly comprehend and understand your actions that day. Because I'm going to tell you, that's not the first time that has ever happened. I'm guaranteeing you that. I'm guaranteeing that is not the first time you've reacted that way. I'm guaranteeing you that. You know that. I'm sure Mr. Davis knows that. You're acting like you're confused, like that was the first time you've ever acted that way.
First time I guess I've thrown anything.
I don't believe that. I highly don't believe that. I don't. If your anger and your boiling of emotion and frustration got to that level where as Mr. Davis said, your head wasn't right that day, but your head was so explosive that day over dirt in a tape measure. And your daughter saying, no, Dad, Ben's going to take me hunting.
I've always taken her hunting too, but
Correct, but that's not the issue. The issue is not who's taking your daughter hunting that day. The issue is you exploded because she got dirt in your tool. You didn't like that. You tried to take something away from her and she stood up to you. She took control. You did not like that. You reacted, you took what you had, the board in your hand, you took that, you used that as a weapon, you gained control by taking that board and throwing it at your daughter. I guess thinking, I thought she'd get out of the way.
I've threatened to take the cell phone away, but that doesn't work either, so.
Oh, so what, did you try to throw a chair at her that time? Okay,
No, she
so
just, I take it away and say you're gonna do dishes. That was another time. She just goes next door to her aunt's house, calls her mom. Then I'm an asshole for taking the phone away. Sorry about my language, but then so I can't win at any of this. I've tried. I don't know how to shut the phone off. I pay for it, but I don't know anything about them.
well, that's not the issue. And here's the thing, what you're trying to do. You're trying to control this situation right now. You're trying to divert this situation of what happened this day, your conduct, your behavior, to throw it back to the other times you weren't able to parent. I don't know. And that doesn't matter here nor there. Here nor there. Today is why you threw a board at your daughter. Why you let your emotions and your anger explode to throw a physical object, a weapon at your daughter that day. Now, do I believe that this does deserve a punishment? Yes, I do. But I do believe that there are other matters in the 24CF case that we need to figure out first, because those are very serious as well. Right now, you're not having contact with your daughter, which is probably a good thing. I can't help her, and I can't order that she get trauma-informed therapy, which she needs. She needs. But what I can order here, I can't do it if I put you in jail right now and I do a straight jail sentence. But what I can do, at least in the meantime of while they're figuring out this 24 case, I can order a whole lot of other things that you do right now. And I can make sure that they're done while we're figuring out what's happening in the 24 case. Because there's a whole lot of things other than anger management and parenting classes and stuff. Those are great. Those are grand. Those are wonderful. Those are not enough. Those are not enough for me to determine whether or not you go and have a full psychological evaluation, that you get evaluated for an in-depth evaluation for narcissism, whether you're a narcissist, whether or not you have a full evaluation of your total mental health, of getting down to all of the nitty-gritty of Mr. Stewart and doing all kinds of other things, because that's what my focus is on right now. I could punish you here today and I could send you to jail for 9 months here today. That's not going to accomplish anything but punishment. And that's not going to do anything in the meantime right now while I'm giving Mr. Schmidt and Mr. Davis time to figure out what's happening in the 24 case. Because I don't know what's going on there. I don't know the facts there. I don't know any of the in-depth there. I don't know what's going on, but I know what's going on here. And I can see here that there's a lot of work that Mr. Stewart needs to do. A full lot of work that you need to do. And I want it done, and I want it done now. So, Mr. Davis, you win. I agree with your argument. Well, not your argument necessarily, but your recommendation. So, at least at this juncture, and at least at this point with this case, I will place you on probation for 1 year. Imposed and stayed jail, 9 months. Consecutive to any other sentence.
Know what that means?
Any other sentence that you may now have or may have in the future.
Your Honor, can you explain to my client what that imposed and stayed means? I don't think
Yeah.
he fully got it when I explained it to him.
All right. So an imposed and stayed jail sentence means I will place you on probation. That means you will be on probation for a period of 1 year with certain conditions that I will lay out for you bit by bit, word for word, so you can understand them. If you fail to accomplish my conditions, you violate probation, you will be revoked. If you are revoked, you don't come back in front of me for sentencing. You will immediately go to jail and sit 9 months of jail, okay? So it means you must follow what I'm telling you to the letter, to the T. Do everything that I'm telling you you must do. All right? Okay? Is that a yes? You understand?
Yeah, yes.
Okay. Now, Ms. Bauer, I don't see any restitution. Is victim going through any type of counseling? That's my knowledge. I am going to hold open restitution, a hearing for restitution for 45 days so that you can follow up to see if she is doing any counseling or any trauma-informed counseling, because I would like to know that, and I'm sure Mr. Davis would like, or Mr. Davis and Mr. Stewart would like to know that. And if she is, and if that's a possibility, please let the court know and we will schedule a hearing, okay? Yeah. All right. So probation, 1 year, 9 months imposed and stayed, again, consecutive to any and all sentences. The court is going to order $1,000 fines, fees, DNA surcharges, all wrapped up in one little bow. Conditions of, you have $250 posted. That means you still have $750 left to pay. That will be paid, that will be due within 30 days to the court here, not to probation. Conditions of probation. 1 is to have a full spectrum, complete mental health, psych evaluation. Absolute sobriety. A full psychological evaluation, which would include a determination of whether or not there's narcissistic personality disorder, any anger disorders, any personality disorders, Again, the absolute sobriety, that means no alcohol, no illegal drugs, no bars, taverns, liquor stores, or establishments that have the primary purpose for the sale or the service of alcohol. No casinos.
I don't go there.
I am ordering an abuser intervention program treatment. That is a program that's designated to rehabilitate those who repeatedly use violence towards intimate partners or family. Because as it was stated, and yes, I understand, Mr. Davis, your argument that it may not be used for conviction purposes, and the court should not use that in punishment purposes, which I didn't. I didn't send him to jail. However, there is a history here of at least charges as it relates to domestic abuse or domestic abuse enhancers, and they've been reduced to either ordinances and or deferred prosecution agreements or deferred judgment of conviction. Therefore, you must do an abuser intervention program that is designed to rehabilitate or focus on individuals that repeatedly use violence and other actions towards intimate partners and or family members. Gainful employment, we don't have to worry about that, but it is one. No abusive contact with your daughter, but no physical contact unless approved by agent or court. And I don't know what's going on with your child support, but make your child support payments.
Oh,
I don't follow up. I don't keep to follow up, but you're not going to tell me what's going on now. I'm just going to say that's a condition. Pay your child support. Keep it up to date. That means you must go and talk to child support and figure that out. If you fail to pay your fines and fees within 30 days, not only will the court enter a civil judgment against you, I will issue a warrant. You will sit 6 months in jail separately from this 9 months that's been imposed and stayed as for contempt for failing to pay. Very important you pay, okay? All right. What am I missing, Mr. Schmidt?
Nothing from me.
Mr. Davis,
Your Honor, I think he may have one, I know he has 1, maybe 2 days of credit. I'm just not certain.
I'll just put 2 days. I'll give him the benefit of the doubt. 2 days jail credit.
He said he sat overnight, but I don't know if he got in before the midnight hour. I just don't know. So I just want to make sure that I'm not saying I just don't know for sure.
I'm good with 2 days. 2 days is good. So what I'm expecting then on the other cases will have a status in February. I'm not expecting, and I'm not saying that it must be resolved by that February date. This is a very serious case, but I want the victims be able to be assured that it is working towards either a resolution or that we're going to be able to set the matter for trial so that we know where this is going. If we need another status, Mr. Davis, after that February date, I'm fine with that as long as the victims are aware of what is going on.
Your Honor, may I ask a question, please?
Yes.
So I understand what your order is with regard to the bond conditions, but he'll have to wait till he meets with the agent with regard to how that, or if there's any contact with his daughter, correct?
He can, I'm fine if he has telephone contact.
I'll talk to him. I just want to be very careful. She may not want to talk to him too. So but again, I just want to make sure that he follows the rules. And then the other thing, Your Honor, with the abuser intervention, is there a specific place that the court uses here in Burnett County, or can we use any different county for that?
No, I'm not, there is not one in Burnett County. I am not quite sure of if there is exactly one that is used by DOC or not.
I see. So they'll probably, I do know that the psych evaluation, I know there's people
I
that do
was
that.
looking at Wisconsin DOC when I was looking at that, the primary treatment programs that they have. I was looking at their website when I was saying it.
So we should let the agent set that up then.
Yes.
Okay, all right. All right, understood. But so nothing, I'll go through the post-conviction, nothing further, Your Honor.
All right, so 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. You must provide your DNA. Failing to provide
to the
that,
agent.
well, you're going to, because you must go report to the jail right now, provide your DNA. Once you're done providing your DNA, you must go report to probation, get all of that set up immediately. This may be something, but I don't know if it is, but it may be a crime that you would be able to have your DNA expunged, but it would need to be a written letter to the Department of Justice, but you would need to do it to the Department of Justice, not to Burnett County. It's easy to do. You can Google it or ask Mr. Davis. Now, I believe that does cover everything, Mr. Schmidt.
The court said a few things about contact with his daughter.
No abusive contact. He can
Yes.
have telephone contact, no physical contact without agent approval.
Well, I'm just wondering because of the bond in the other case.
That just says no victim. That applies to the victim of that matter.
But it also says no contact with minors under the age of 18 without full eye supervision. I don't know what full eye supervision means.
It means you have to be in the same room and look at them at all times.
Because the other component of that is, of course, his daughter is a witness against him in that case. She is juvenile witness 1.
Well, it doesn't say, that bond does not say no contact with witnesses. And the
Okay.
state did not ask to have no contact with witnesses. So if you're going to be asking to modify that bond to have no contact with daughter, that would be for the state to motion the court to modify that bond.
To be blunt, I thought the no contact with minors under 18 already covered it.
Does
So-
not.
Okay. We'll file something in that case then.
Well, we're here today, so
That's true. I would ask no contact with his daughter in 24 CF 163 as a condition of bond.
until it's resolved,
Yes.
Mr. Davis.
Well, Your Honor, I would ask for time to prepare for this motion.
Well, what I'm gonna say is there could be no contact with his daughter about the matter specifically relating to 24 CF 163. Ms. Bauer,
The last time I spoke with the victim, she did not want to have contact
daughter?
with daughter.
Well, and she can
She's-
refuse contact all she wants, but I will modify bond that says no. In 24 CF 163, no contact with daughter, or no communication with daughter concerning the facts of this case.
And I will tell him that he'd be insane to do that because he could wind up with more felony charges by doing that.
Can I send a birthday card, Christmas card? I mean, I have it all at home. Just,
Yes.
can I do it or not?
I'm not saying no contact. She can refuse it.
You saw the bond, that's so.
I'm just trying to make sure it's clear because I've been waiting for these answers for a long time.
And if she further wants no contact, Ms. Bauer, that would need to be a specific motion because I've never heard that prior to just now.
Anyways, yes, and Your Honor, so he will not mention anything about the case. And she, like you said, she may not want to have contact. And he understands that if he does have contact with her, there's got to be 24/7 eyeballs there of an adult seeing that contact.
Correct.
So yes, he understands that.
All right. Anything, but you do understand that she can refuse any contact. Like if she doesn't want that birthday card, she can say refuse, return to sender. Or she can go click, send a voicemail, or she can block, or whatever she wants to do. That's her choice. There is no court order, at least that I'm aware of right now in the family matter, that says that she must have contact with you.
Thank you, Your Honor. Nothing further from the defense.
All right, then we are adjourned. Thank you. All right, how are you doing today? I'm good. I'm sure you're feeling a little anxious. A
Yeah, a
lot
little
of
bit.
feelings.
Little anxiety there, but
Got a cool shirt.
What?
Got a cool shirt.
thank you.
Miss Hanu, timing wise, we're all good for today to proceed as it is.
Yes, Your Honor.
Excuse me, I put my hearing aid in.
Okay, you do that. And if you need me to speak up, let me know. If you need me to turn up the system, let me know.
It's just my hairs.
So who's here with you?
That's my mother and my aunt.
Very good to have their support.
There we go.
Anybody was curious, records prior to 1999 are stored in the basement of the Hennepin County Courthouse.
What?
I went to Hennepin County to dig through records.
Did you find anything?
No.
Nothing? But you tried hard. That's good. That's the problem with having things old, but now with everything in technology, we'll have records forever. Unless they let us purge them and delete them from a system.
Well, Washburn County's been down for about a week.
They're still down.
Yeah, they're going to be down for at least another week.
Everything?
So the DA's office runs off the state system, so they're all running off hotspots right now. So there's no phones, there's no Wi-Fi.
Wowza. All right, we will go on the record in the matter 25 CF 159, 25 TR 956 and 957, State of Wisconsin versus Eric Gustafson. The state appears through District Attorney Kevin Schmidt in person. Mr. Gustafson appears in person with his counsel, Emma Hanu. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. Ms. Hanu, can you please recite the agreement for the record?
Yes, Your Honor, the agreement would be for Mr. Gustafson to plead to count 1, operating while intoxicated, a 5th or 6th offense. The remaining counts would be dismissed and read in. There are additionally 2 traffic matters that would also be dismissed and read in. That would be 25 TR 956 and 957.
All right. And Mr. Gustafson, that is the agreement that you've reached with the state?
Yes, Your Honor.
You understand that pleading guilty to an OWI 5 or 6 means that it's an immediate report to jail and that it's a mandatory minimum prison sentence. And that would be, as of me taking your plea, you're going to go and be incarcerated.
I understand.
Okay. All right. So I do have in front of me the plea questionnaire waiver of rights form. Do you recognize the document?
Yes, Your Honor.
Is this the document your attorney went over with you?
Yes,
Did she go over it thoroughly with you? That is essentially word for word?
yes,
And do you understand everything completely?
yes.
If you did not understand something, did you ask her to explain it to you?
I understood everything.
All right. And so you signed the second page.
Yes, Your Honor.
You're pleading guilty to one count of operating while intoxicated, fifth or sixth offense. You are 70 years old. You have 12 plus years of schooling. You can read, write, you understand the English language. You are receiving treatment for a mental illness or disorder, which would be ADD or ADHD,
Correct.
and you are taking medications for that. Is that correct?
Up until my last appointment, because they won't allow it in prison, so I told them not to make it, because it has to be monthly, I have to go in.
Okay, now today, since you have not been taking it as you have been regularly prescribed the medication, are you in a place today where you can say that you are able to comprehend and understand everything that's going on?
Yes, Your Honor, it only affects my ability to concentrate.
All right, now, are you in a place here today where you can concentrate
Yes,
fully?
Your Honor.
Okay. Other than that, no medications, no drugs?
I have my
Or
own
alcohol?
medications, but those are just blood pressure,
All the
cholesterol.
normal health
Yeah.
stuff? Okay. Now, because you're charged, well, first off, did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt as to this OWI 5 or 6?
Yeah,
And did she go over with you the mandatory minimums as well as the possible maximum penalties you face upon conviction?
the minimum, yeah, I don't even know what the maximum is.
Well,
10 years.
Oh, 10 years, okay.
all right, so your attorney just informed you the maximum possible penalty. So you understand the mandatory minimum as well as a maximum penalty.
Yes,
Okay. Now, because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed right there in that first page. Your attorney is showing you your constitutional rights right now. Did your attorney thoroughly go over those rights with you?
yes,
And do you understand them completely?
yes.
Do you need me to go over those rights with you in any more detail?
No, I'm fine, Your Honor.
Okay, so you understand your rights completely. And do you understand that by pleading guilty, you are waiving and giving up those rights?
Yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
that's why I don't own any.
Excuse me?
I don't own any, so that's
Oh,
why.
that's good. And you will no longer be able to vote in any election until your civil rights are restored.
With this political climate, why bother?
Well, that's good too. Okay, but every vote does count. Okay, so you understand your rights and you understand what you're giving up here today and that it's a felony. You
Yes,
understand that with regards to this charge, the operating a motor vehicle while under the influence, fifth or sixth offense, the state would have to prove on or around November 15th, 2025, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant. Do you understand what the state would have to prove?
yes,
Do you understand that upon conviction of this Class G felony, you may be fined not more than $25,000 or imprisoned not more than 10 years or both? That's the maximum possible penalty. Do you understand that?
yes, Your Honor.
Do you also understand that upon conviction due to this felony and the seriousness of this OWI, that the court shall impose what's called a bifurcated sentence, meaning some time that you would sit in prison and time that you would sit outside of prison on extended supervision, that the court shall impose a confinement portion of that sentence to be not less than 1.5 years of initial confinement in prison. Do you understand that?
Yes,
And do you understand that in certain circumstances, it's not very common, but in certain circumstances, the court could find that a lesser sentence would be reasonable if the court finds the best interest of the community would be served and the public would not be harmed for a lesser sentence than that mandatory minimum. Do you understand that?
yes, Your Honor.
But you understand that's not an everyday thing that occurs. You understand that?
Yep.
Okay. So you understand the minimums, you understand the maximums, And you understand what the state would have to prove your guilt beyond a reasonable doubt. Now, do you understand that there is an agreement here reached between the parties where the parties would recommend to the court just to sentence the mandatory minimum in this case? Do you understand that?
Yes,
Do you understand that I'm not bound to follow that? Which means I could look at this case, I could hear the arguments, and I could sentence you beyond that minimum sentence, and I could go all the way to the maximum penalty if I thought it was warranted. Do you understand that?
yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Now, did you go over that criminal complaint with your attorney? That's the initial charging document that says basically what happened that day and why you were charged with the crimes.
Yes, Your Honor.
And you're looking at that right now with your attorney, correct?
Yes, Your Honor.
Now, for the most part, are those facts accurate?
They are.
So you were pleading guilty to an OWI 5 or 6 because are you guilty?
Yes, I am, Your Honor.
And so you're admitting to operating while under the influence on November 15, 2025?
Yes,
Ms. Hanu, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated, Your Honor.
Has anyone made any threats or any promises to you, Mr. Gustafson, for you to plead guilty today?
no, Your Honor.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing.
Yes,
Are you doing so voluntarily?
yes,
Has your attorney represented you competently?
yes,
Has she answered all of your questions?
yes,
Has she looked at this matter thoroughly?
yes,
Has she looked at the discovery, which is the evidence here in this case?
yes,
And has she discussed it with you?
yes,
Has she looked whether or not you have any legal defenses in the case or a lack of defenses? Did she say, you know what, looking at this case, it looks like we can argue to the jury and or the court that you have this defense and we can probably argue that and maybe
wait,
find you not guilty? Mr. Gustafson, you can have a few minutes to talk to your attorney.
oh, okay, yeah. Yes, we talked about it.
Okay, and as she stated previously, I don't believe it was on the record, but prior to the record, that she went to Hennepin County, she went to go look at other OWIs that you've been convicted of to see if they had records of this, to see if you could possibly have what's called a collateral attack, which could be something that assists you in this case. Did you talk to her about that as well?
Yes, Your Honor.
Okay, so are you satisfied with her services?
Yes,
Do you have any questions for the court or for your attorney before I proceed?
no,
Okay, Ms. Hanu, did you go over the facts that are alleged in the criminal complaint with Mr. Gustafson?
Yes, Your Honor.
And did you go over what the state would have to prove his guilt beyond a reasonable doubt?
I did, Your Honor.
And the mandatory minimums and the maximums?
Thoroughly, Your Honor.
And you discussed whether or not you could see any defenses or a lack of defenses in this case?
Yes, Your Honor.
Do you believe he is competent to enter his plea here today?
I am.
Any reason the court should not proceed and ask for his plea?
No, Your Honor.
All right. Mr. Gustafson, as to count 1, OWI 5 or 6, a G felony, how do you wish to plead?
guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be dismissed and read in. Count 3 will be dismissed and merged into count 1. The ticket matters will also be dismissed and read
Retain
in.
them.
A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you. I think that the statutory minimum here is appropriate in this case. The defendant's got 5 prior OWIs, meaning this is a 6. The significant things that counsel for that are 1, the defendant's old age, which is 70. 2, he's been accepting responsibility quickly, not just with the court, not dragging things out, but also when he was in contact with the police out at the scene, he didn't really deny or anything like that. 3, he has a significant additional penalty in this case, and that even though this is a 6, it's his first felony conviction ever. The way Minnesota counts convictions is much more lenient than Wisconsin, which is how he's dodged that His convictions are spaced out such that he never had 3 within a 10-year period. So he never had a felony OWI in Minnesota. So he's going from his last OWI in Minnesota where the penalty was just, 90 days jail, probation with 275 days stayed imposed to accepting prison today, which is a big jump. And I think that that alone is sufficient and there's no need to ratchet higher than that. Thank you.
Thank you. Ms. Hanu.
Your Honor, the factors you must consider here, the gravity of the offense is the statute as well as common culture creates the gravity is high here. I'm sorry. Operating while intoxicated is a issue here in Wisconsin. But the other factors that the court must consider is Mr. Gustafson's character and his rehabilitative needs and the protection of the public. Mr. Gustafson, as the court saw when we came here for a bond modification, was adamant that he wanted to go to treatment. He wanted to go get help prior to what he knew at the time would be an immediate report to prison. Mr. Gustafson was released from the Burnett County Jail on January 22nd of 2026. I have in my hand here a letter from the Veteran Affairs Association that by February 1st of 2026, Mr. Gustafson took the time to go to St. Cloud, Minnesota and enter into the mental health residential rehabilitation treatment program with the Veterans Affairs Health Center in St. Cloud. He completed that program on March 19th of 2026. Mr. Gustafson is committed to his sobriety. He served this country. As I think we all know, veterans often will struggle with sobriety, addiction issues following their service. As Mr. Gustafson has related to me, this came from a downward slope where he knew he needed help and he didn't get it in time, and now we are here. Mr. Gustafson is taking responsibility, and he is here today for the court to impose a sentence. I think the mandatory minimum is more than appropriate and adequately protects the public, because even after a term of confinement where Mr. Gustafson could get out, do his extended supervision and be done, he intends to re-enter into the Veterans Affairs treatment programming to ensure long-term sobriety.
All right, thank you. Mr. Gustafson, is there anything you want to add or you want to let me know?
No, like I said, I knew I was going, I just procrastinated. That's my biggest crime. Just trying to find my paperwork from previous groups I was in.
All right. Mr. Gustafson, sentencing people is not easy sometimes, because especially I'm going to say for me, because I like to look at the person and I like to know about the person. So I have a good idea of who I am sentencing instead of just seeing the black and white. On black and white, if I were to just look at the facts of the case as alleged in the criminal complaint and those things, on black and white, it's serious. It's an OWI 5 or 6, and somebody could have been killed, somebody could have been injured, that could have been you, it could have been someone else. And if judges sentence on the black and white, you could go to prison for up to 10 years. I like to know the person who I am sentencing, to know the history, to try and craft a sentence around that person and that person's needs, as well as then looking at the punishment factor and what I am directed to do by the legislature and by my higher courts. From the very beginning, you have wanted to be responsible and be accountable, and you understood that, and you knew that you could just stay in custody and wait until the matter worked itself out, such as now, and plead guilty and go to prison. You could pay the bail and get released and then live your life until it reached resolution such as today. But you decided to pay the bail, get out of custody, go to the veterans facility and get the help that you need, mentally, physically, all around. Even still knowing that there is a mandatory minimum prison sentence in this type of case, you still went ahead and got the help that you need as a person. That's commendable. OWIs are very serious. Not only the legislature tells us that they're serious with continued increase, significant fines and fees, and significant penalties for OWIs. But you and everyone else in this courtroom, and including myself, know how serious they are, because we either know somebody, had somebody in our family or a friendship or an acquaintance, or read in a paper or watched on the news somebody who was either killed or severely injured in an accident caused by intoxication or people being under the influence. So we all know that it's serious. You do have a criminal history, and it's obvious with the OWIs. This would be your first felony OWI, and in Wisconsin, it's mandatory prison. The community, I have to look at the community and protecting the community, and here the community is going to be protected, one, because you went and got the treatment and the help that you need. And second, because this is a mandatory prison sentence and you're going to be incarcerated and you're going to get that punishment end of this crime. And so the community is going to be protected that way. Hopefully, when you are incarcerated, you will avail yourself of all of the programs and all of the activities and all of the things that you can to continue to improve yourself and to be able to have more self-reflection as to why this happened, what led this to be the result, and how you can catch things sooner or seek help faster instead of getting into another position like this. You're a 70-year-old man who appears to be kind and sweet, and you have support of your family, which is great to see too. So sentencing you today is not an easy thing, knowing that I must, I have to sentence you to prison. I don't think there's anything here, though, that would state that I need to or should look beyond the mandatory minimum prison sentence, because your criminal OWIs they're sparse in time, and you're doing all that you need to do, which is, again, commendable. So the court is going to sentence you to 1.5 years of initial confinement with 3 years of extended supervision. You will not be entitled to do any early release programming for that initial 1.5 years of incarceration, because that is a mandatory minimum sentence. However, once you're placed on extended supervision, if you are revoked off of that, at that time, you would be able to engage in some types of early release programming, substance abuse programming for early release, if you are revoked off of extended supervision. I am going to order $4,962 in fines and fees, plus a $10 blood draw fee. With each and every OWI, the fines and fees get higher and higher and higher. And I'm trying to give you as much of a break as I can, knowing that you're taking the responsibilities, because this could be up in the $6,000 range. I understand you're a veteran. I understand you're on limited resources. We do have $2,000 bail that has been posted. That'll go towards your fines and fees. When you're released from custody, you can petition the court to look at the fines and fees and see if there's anything that you can give back to the community, working with the veterans and doing those kinds of things, where I could perhaps knock some of the fines and fees off for community service.
Well, I've already made the decision to help out at the VA and local animal shelters.
And I'm glad to hear that. And you're telling me you're doing that without even having an incentive, without even having a benefit from doing that. So that makes me even happier. So when you are released, and if you are looking, or you would like some money knocked off to the extent that I'm able to, I am very happy to take your service with those organizations and help deduct some of the remaining cash that need, fines and fees. I can't waive any surcharges, but I can look at other fines and fees to try and whittle it down.
I don't,
We're out of custody. You will be making payments in the amount of $150 a month. If you're unable to afford that, again, you can petition the court. We can go over your finances and we can see if that needs to be looked at. Sometimes the court looks at your financial situation and looks at everything and actually increases the monthly amount. So just be sure that you don't think that that is a possibility. That would be, well, when he's on extended supervision, yeah, that would be to the Department of, correct, no, it won't. Let's have him pay us when he's released, because the Department of Corrections, he's gonna probably be watched in Minnesota, supervised in Minnesota, because you live in Minnesota, correct?
yeah, so when I get out, my family there lives up in Viking Village. At first I'll be going there
Okay,
because they need some help
all right.
mentally.
I do have to state that the Department of Corrections, in their discretion, could take a percentage for these kinds of fines and fees, and I'll leave it to them, but I'm comfortable with my comfort is you don't need to start making payments until after you're released, but the Department of Corrections gets to do what the Department of Corrections wants to do. And so if they have the authority to do that and to collect, and if they are looking at collecting, then that's something that you unfortunately have to take up with the Department of Corrections when you are in custody. On extended supervision, absolute sobriety, no alcohol, no bars, taverns, liquor stores, or any establishments that have the primary purpose for the sale or the service of alcohol. You will have alcohol testing. How many days of jail credit?
69, Your Honor.
69 days of jail credit will be applied to your sentence. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, not only will the court enter a civil judgment against you, because you're always going to owe it, but the court will issue a warrant. You could sit up to 6 months in jail. This is a felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. You're going to need to contact Burnett County Probation when you're in custody, or they will contact you, because when you are released, you're going to want to do that interstate compact, and you're going to want to transfer supervision to whatever jurisdiction you're residing in after release. I believe that covers everything. I need to order your DNA. The jail will make sure that they take that. In a case like this, I do not believe you can request it be expunged from the system, but you can try. It's a written letter to the Department of Justice. Ms. Hanu can help you if you wish to look into that.
At my age, I'm not too concerned about that.
Well, I'm glad to hear that. No, we don't have to worry about any past crimes where DNA will solve the mystery. So that's good. Thomas Avenue, is that your home?
That is my nieces. I've been there, but like I say, I'll be going there. I've been here for the last month helping them, and then I'll be going there when they first get out. And I don't know where I'm going because I think she's going to be moving to Florida while I'm incarcerated.
Okay.
I'm
just
hoping to
make-
go back to the neighborhood I used to live for 18 years till I had to move. That's why I went overboard there.
oh, Just make sure that you have the Department of Corrections and the court updated with any change in address where you want mail to be sent, but they'll update us with where you are incarcerated.
I do have a change of address into my niece over in Hastings, Minnesota, that my mail will be going to.
You have an address you want to give us right now?
Yes. Let me pull it up. I'm trying to be proactive. Uh, 1988 Nininger, and that's spelled Nininger Road, Hastings, Minnesota, 55033.
Okay, thank you. All right, Mr. Schmidt, what am I missing?
Nothing from me.
This is an immediate report, so once you're done here today, in court, you have to go to the jail, turn yourself in, and get booked in, and good luck to you, Mr. Gustafson.
So I brought these.
Good luck. Anything you think I'm missing or need to state on the record?
No, Your Honor.
Okay, thank you.
I just go down to the sheriff's office.
Yes, Ms. Hanu, do you have another case? Can you just show them how to?
I have
Thank you.
I've been there before.
Okay.
Have a good day, Your Honor.
This courtroom hearing takes a serious turn as 70-year-old Eric Gustafson appears before the judge to enter a guilty plea to a 5th or 6th OWI offense. The agreement means the remaining charges will be dismissed and read in, but the judge makes sure Mr. Gustafson fully understands what he is facing. She explains that this is a felony carrying a mandatory prison sentence with a maximum possible penalty of 10 years. He confirms that he understands the consequences and still wants to plead guilty. The judge carefully goes through his constitutional rights, the possible penalties, and the facts of the case before accepting the plea. Mr. Gustafson confirms that his attorney reviewed everything with him, that he understands the evidence, and that he is pleading guilty freely and voluntarily. The court ultimately finds the plea knowing, intelligent, and voluntary, and enters a judgment of conviction. During sentencing, the prosecution asks for the statutory minimum, pointing out that this is Mr. Gustafson's 6th OWI, but his first felony conviction in Wisconsin. His attorney emphasizes something important. Instead of simply waiting for prison, he chose to seek treatment. He completed a residential rehabilitation program through Veterans Affairs and demonstrated a commitment to sobriety. The judge says sentencing is never easy, especially when she takes the time to understand the person behind the case. She recognizes that an OWI 5th or 6th offense is extremely serious,